Knowing she wanted to be an attorney, Heidi began working in law offices at the tender age of 14. I don't know what she was doing, hopefully just filing papers. After graduating from USD, she went on to obtain her Juris Doctorate from California Western School of Law, and she graduated in the top third of her class. During her time as a law student, Heidi concentrated her law studies in the areas of estate planning, tax planning, and corporate business law. She has been serving as an estate attorney for some 18 years now, since 2004. And she has been serving as RA Select Professional Partner for all of our Retirement Association legal presentations for over 15 years now. Please welcome Heidi Klippel.
Well, thank you, Suzanne, for that nice introduction. I will say my first job at a law firm was I was stocking the soda machine at my dad's corporate attorney's law firm. That was kind of my way of getting my foot in the door. I wondered about that.
I hope you weren't filing motions. Okay.
But I thought that was a big deal, being able to go and check and see what sodas were in short supply and going to the grocery and stocking up on them. I thought I was a real big deal getting to go from school to a law office to the grocery store and doing that. But anyhow, thank you all so much for your time today and attending this presentation. Today we are talking about trustees and private fiduciaries. So for those of you who are a trustee, I'm going to basically give a step-by-step explanation as to what that job involves. For those of you that have an estate plan, I'll also be explaining how this works as far as your estate plan. To be honest, when you do an estate plan, picking your successor trustee is honestly the most important decision you're going to make as far as having a viable estate plan that's very effective and efficient versus not. So for those of you who have an estate plan, when you create an estate plan, you usually have 4 different legal documents in it. One is a document called a trust, another is a document called a will, another document is called a durable power of attorney for financial affairs, and the 4th document is called a medical directive. So when you pick a trustee, you're basically picking a person that you entrust that would manage your financial affairs if you lost capacity. One of the biggest benefits of having these documents is when you create these documents while you have capacity, because you make these decisions during lucid moments, the courts will give these documents deference when you lose your capacity and no longer are having lucid moments. So to me, one of the most important benefits of doing an estate plan is in all of our family circles and close friend circles, not all of our loved ones are necessarily financially astute. So if you were to lose your capacity, it is a very beneficial thing and peace of mind for you while you had capacity to be able to pick the people that you know and trust that could step into your shoes legally and become your financial advocate when you don't have the capacity to make those decisions for yourself. So when you have a document called a durable power of attorney for financial affairs, what that document is doing is that document is naming people to make financial decisions for you when you lose capacity over all financial transactions that are not part of a trust. So when you create a trust will also have a nomination for what's called a successor trustee, where you're nominating people to manage assets that you've titled into the name of the trust if you were to lose your capacity. So it's important to understand that when you have an estate plan, you actually have 2 different documents that give these powers. So the nuance is when you create a trust, you want to think of your trust metaphorically like a bucket. So once the trust is in place, you're then going to move all of your assets into the name of the trust so that those assets are inside of the bucket. So if I create a trust and if I were to lose my capacity, my trust has my husband as my successor trustee, which would give him my legal permission to manage the assets that are in the trust if I lost my capacity. So for example, whenever you create a trust, you always want your house to be titled in the trust, because when you pass, if the house isn't titled in the trust, that will trigger a court process called probate. So one really important benefit of having a trust is if my husband and I were refinancing our house, taking advantage of these super low interest rates, but if I were hit by a drunk driver and now I'm in the hospital and I'm in a coma and I don't have capacity, my husband legally cannot sign my name on that mortgage document unless I've given him my contractual permission to sign my name. So when you have a trust, there's language in the trust that says if either spouse or if a single person were to lose their capacity, then the trust would give powers to the successor trustee to step in and take over the management of the assets that are titled in the trust. So in my hypothetical, if I'm in the hospital in a coma and if my husband needed to sign my name on a mortgage document, legally my trust is only going to give him my contractual permission if and when I lost my capacity. So before my husband can actually sign my name on that document, he would need to take me to either my primary physician and have my physician write up a doctor's declaration stating that in my physician's opinion, I lack the capacity to manage my financial affairs, or he would have to get 2 separate letters from 2 separate doctors that aren't my primary physician attesting to the same facts. So once you attach the doctor's declarations stating that a person no longer has the to make reasonable and informed financial decisions to the trust, that's when the that's when the power transfers from the owner to the successor trustee. So between a married couple, generally the well spouse is going to be the first person to take over when one spouse lacks capacity. And for a single individual, you'll have a first, second, and third successor trustee nomination in your trust. So if I were to lack capacity and if my house were in the trust and if my husband got the letters of incapacity from my doctors, that's what would legally give him my permission to sign that mortgage document. If he signed that document, signed my name on that document without going through those legal hoops, technically that would be forgery. So it is beneficial to have the doctor's statement, because without it, you would actually be committing fraud if you signed a non-well spouse's name on that document, even though they technically lack capacity. But in the state of California, it's generally the doctor that is going to make that medical determination, because you do want a medical decision to be made by a medical professional. So again, one nuance between a trust and a durable power of attorney for financial affairs is the trust is going to give the person that you named in the trust your contractual permission to deal with assets in the trust. And typically those assets in the trust will include your house and any other real property, timeshares, checking accounts, savings accounts, money market accounts, and any other taxable investment account. Because in California, you want all of your taxable assets titled into your trust, because that's how they stay out of the probate courts. When you have a document called the durable power of attorney for financial affairs, what that document is doing is that document is giving people the power and authority to manage assets that are not in the trust. So it is, when you own a retirement account, you legally have to own that account in your own name under federal law. So in my hypothetical, if I was in a coma and if I lack capacity, and if I needed to take a required minimum distribution from my retirement account, then my husband, through my durable power of attorney, because that asset is titled in my individual name, that document would give him my contractual permission to step into my shoes and to deal with assets that are not titled in the trust. So when you have a durable power of attorney and a trust, you're going to name the same people in the same order in those documents. So in my trust and durable power of attorney, my husband is my first choice, and then we both have the same person in both documents as our second choice, and the same person in those documents as a third choice. So when you create a durable power of attorney and a trust, even though they're technically separate documents, the people and the order that they appear will be the same in both of those documents, because it wouldn't make any sense to have one person in charge of the trust assets and to have a different person in charge of non-trust assets. So when you pick a trustee, it's really important to pick somebody that's financially responsible, somebody that's trustworthy, and somebody that's proactive. What you wouldn't want to do is pick that family member who is the type of person that when life happens, they need some downtime, and their way of coping is to climb under a rock and shut the world out, which I'm not criticizing that approach, but we all approach things differently. And in my experience of being an estate planning attorney, I've seen people cope with stress and grief and loss by needing just to have some downtime. I've seen other people deal with that same type of emotion by being very proactive and being very busy. So ideally, if you've got people in your life that are the busy type, you want somebody who's going to be proactive, who's going to get involved, and you need somebody that's trustworthy and who's diligent, because if you were to lose your capacity while you're living, you need somebody at the helm of the ship who's paying your mortgage and your property taxes on time. And then when you die, a trustee's job becomes very different. So it's important to understand that in the state of California, when you nominate a trustee, you're basically nominating them to do two potential different jobs. One job is if you were to lose your capacity while you're living, their job, if they accepted the nomination to act, would be to be your financial advocate, to pay all the bills, to make sure that the taxes are paid, the insurance is being paid. So while you're alive but incapacitated, they basically become like your accountant. But then when you pass away, a trustee's job is very different, and their job at the time of your death is to administer your estate. So in California, when a person dies, an estate has to be administered. So a trustee's job is first to determine whether or not an estate has to go through probate. And that is why so often so many people in California have trusts, because when you have assets in trust or have assets that pay on your death to a trust, those assets are not subject to probate. So one of the first jobs a trustee has to determine is whether or not any asset has to go through probate. Assuming that there is no probate, the second job that a trustee has to do is they have to send out what's called a notice to beneficiaries. And the purpose of that notice is to notify the beneficiaries of a trust that a person has died and that the trust is now irrevocable, and that the person sending the notice has agreed and is acting as the trustee. So when you send the notice, the beneficiaries have a right to read the trust. The beneficiaries have a right to know who the trustee is. So if they have questions about the trust administration process, they know who to call. And then they also are able to call and ask the trustee questions. So when you nominate a trustee, you are just nominating them. So that's why it's always important to have at least 3 to 4 people named, because there is always a possibility that the first person listed might decline the nomination, in which case it's good that you have a second person named. If the second person named is no longer legally capacitated, which means they're no longer eligible to be your trustee, that's why it's good to have a third person named. And if during the trust administration process, the trustee needs to resign, because there is the flexibility of resignation included in these documents, that's why it's always prudent to have a fourth person listed if possible. So just know when you nominate trustees, you are just nominating them. So the individuals listed do have the ability to decline the nomination. They also have the flexibility of resignation. So during your incapacity or during the trust administration process, if they needed to resign, they can resign at any time. So that again is one of the purposes of the notice to beneficiaries, is to notify the beneficiaries as to who the acting trustee is. Now, my recommendation for a trustee is to always seek the advice of an estate planning attorney before accepting the job to be a trustee, because I think it's important to understand the nature and scope of what it means to be a trustee. I think it's also important to understand that you do have the ability to decline the nomination. And if you accept the nomination, what does that job look like? When you are a fiduciary, it is a fiduciary responsibility, which means even if you make an innocent mistake, the beneficiaries can take you into court and a judge can find you liable. If they find you liable in court, they could assign what's called personal liability, which means if the judge thinks that you made a mistake that a reasonably prudent person in similar circumstances wouldn't have made, they can make you pay out of your own pocket to remedy that mistake versus using trust monies. So when you are nominated to be a trustee and when a person dies or when a person becomes incapacitated, it really is important to first really think about, are you willing to do this job? I know a lot of my clients will ask me if I'll be their trustee, but truly you don't need a trust attorney as your trustee. What you need is somebody who's prudent, trustworthy, responsible, impartial, that would treat your beneficiaries fairly and impartially. And you want somebody that would take the job seriously. All trusts and durable powers of attorney have language built into them that allows the individual that you nominate to use monies from your assets to pay an estate planning attorney to advise them. So I always explain to my clients that that's truly my role. My role is to advise a trustee and a durable power of attorney as to what it means to do those roles effectively and efficiently. You don't need to pay an attorney's salary to do those roles, because honestly, with all due respect, anybody can write checks every month and pay the mortgage and the property taxes. You don't need to have an attorney do that. Now, sometimes my clients will ask me whether or not it makes sense to have a corporate trustee versus a private fiduciary. And if you don't mind, I'm going to answer that question in a couple of minutes. First, I just want to finish explaining what trust administration looks like. So when a person dies, and after the trustee has determined whether or not there is or isn't a probate, the trustee does send out the notice to beneficiaries. And usually that's when you're going to have an estate planning attorney assist you, because there is specific language that has to be included in those notices for those notices to be deemed legally effective. The purpose of the notice to beneficiaries is to open and close a statute for a beneficiary to contest your estate. So in California, when you send the trust and the will and any current amendments applying to those documents along with the notice, a beneficiary has a 90-day period to contest the estate. Most often people don't contest the estates because most estate plans do include something called a no contest clause, which basically says if you do contest an estate and if you lose, then you forfeit your right to inherit. So there are obviously trust litigation cases that do occur in California, but I don't think it's as common and as prevalent as you would think it is based on movies and television. So most people, given the opportunity and choice to inherit versus to pay monies out of pocket to challenge an estate and possibly risk the chance of inheriting, would rather inherit than not inherit. And that's truly why the no contest clause came into being, is because California knew that giving a beneficiary a choice versus inheriting versus not, and paying out of pocket to possibly not inherit and to have the burden of proof to show why they should inherit more, or if at all, oftentimes people will choose not to contest. So when a person passes and that notice to beneficiary is sent, the trustee then has a 90-day period to basically gather all the asset and debt information on the decedent. So one of the things I encourage my clients to do that we give in our estate planning binders, which I assume probably a lot of other estate planning attorneys also provide, is there is a financial document that we encourage our clients to complete that includes all of their financial information. The purpose of that document is if I were hit by a drunk driver and if my loved one needed to step into my shoes and pay all of my bills, I have a bill pay summary in my estate planning binder that outlines when my bills are paid, how my bills are paid, if I pay bills online, what my logins and passwords are, because most of us take for granted when we pay our own bills and when we change passwords, yes, we're aware of all the logins and passwords and all of that information, but our loved ones are not. So in your estate plan, if you don't have a place to fill out what your financial bills look like on a monthly basis, I would encourage you to create a document and to include what bank accounts you have, where they're located, what your account numbers are, if you log on to your accounts online, what's your login, what's your password. And I would keep all that information with your estate planning documents, because if that third party successor trustee did need to come in and take over the management of your finances, why not have a nice little roadmap already in place for their benefit that shows when bills get paid, how bills get paid, logins and passwords and things like that. Now, obviously, if you're going to create a document like that, you need to keep it in a safe place. My husband and I have a safe deposit box at our bank. If you open up our safe deposit box, you will not find any fancy jewelry. You will not find any fancy coins. All you will find in our safe deposit box is a chip. And basically, or it's not a chip, it's a flash drive. But on the flash drive, we've got our financial information that shows when we pay our bills, how we pay our bills. We've also scanned onto that flash drive our insurance information, homeowners insurance, car insurance, medical insurance, so that if our house were to burn down, all of that important information on the flash drive that's outside of the house that we would have access to. So for those
Heidi, may I jump in for just one tiny second? So there's a really good thing that I also want our members to know about. It's called LastPass, and it's a vault where you can save all of your passwords for everything, and you can set it up with an emergency access, and you identify who the people are that if you die or if you're lacking capacity, then it would send an email to those people and notify them that they have access, and then they can get access to all of your passwords online.
That's great. Yeah, that's fantastic. So I would do that. That's even better.
Yeah, I set mine up. I love it. Yeah.
Perfect. So you do want to have something like that. And for those of you who have an estate plan or are thinking of setting one up, I don't think you need to share any of that information with anybody right now. But it would be good for your loved ones to know that you have that information and where they could locate that information should something happen to you. So I do think having that information in place is prudent. The other thing I think is prudent is I have on my calendar as a reoccurring event, basically January 1st of every year, because my husband and I aren't big New Year's people. We sit down at, well, he goes to the file cabinet. I have my master list of accounts, and he basically goes through all of our bank accounts, life insurance policy, and tells me what the account numbers are. He tells me what the logins and passwords are, what the bills on each of those assets are. And I take notes every year updating all that information, because generally speaking, that information will change. If you have life insurance, the cost tends to increase every year. Your account logins and passwords might also change. And if they haven't, you might consider changing them just so that you're currently updating passwords. But that is a very important piece of passing the baton to a third party successor trustee, is having all that information in one location, having all that information organized, because oftentimes people will ask me, what can I do to make my trustee's job a little easier? And that truly is the number one thing, is having all of your financial information organized, having all that access information as far as logins and passwords in one central place. So going back to trust administration, which is a very big role for a trustee after a person dies, is once you've sent out the notice to beneficiaries, and during that 90-day beneficiary period, the trustee's primary job after you die is to pay a decedent's bills. And I don't know why that surprises people, but I have a lot of people that call me when a loved one has died, and their question is, when do we get the money? And I'm always so surprised that people assume that when a person dies, the monies are automatically exchanged, because there is a due diligence process in California that is legally required, where part of a trustee's fiduciary duty is they legally have to pay all the debts, bills, taxes of a decedent before any beneficiary can inherit. And I had one person call me one time who said, well, what I'm going to do is I'm just going to make my kids the pay on death beneficiary, because I know when I die, if all of my debts pay directly to my kids, then my creditors can't come after those assets. But that's really not the proper way of structuring an estate in California, because there are laws that require that all the debts get paid. So if you pay on your debts all the beneficiaries and there's not a bucket of money that's made available to a trustee to use from that bucket to pay those expenses, then legally the creditors can come after all the kids that inherited the monies directly and lien the assets and basically get paid those monies back. So another benefit of having this trust in place is when you put assets. Oh, how does the trustee get information? Okay. Warren just asked a quick question I'm going to answer because it's on topic. Is he said, how does a trustee get information to a safe deposit box? So when you have a safe deposit box, you want to title that safe deposit box into the name of the trust, because the trust has language within it that says that if your doctor did make a determination of incapacity, in which case, once you show the letter of incapacity along with the trust to the bank, they'll let the successor trustee have access to that safe deposit box, and the trustee's under a fiduciary duty to do with the contents of that box what the trust says. Or when a person dies, if the safe deposit box is titled in the name of the trust, once the trustee has that final death certificate, the trustee will take the trust along with the death certificate into the bank, and that's when the bank will release those the safe deposit box and its contents to the trustee for the trustee's safekeeping. If you have a trust and if the safe deposit box is not titled in the trust, then the trustee has to wait a period of 40 days before the bank will give the trustee access to that box. And when the box is not titled in the trust, most banks will charge a drill fee. And I've seen that drill fee be anywhere from $75 to as high as $375 for the bank to give the trustee access to the box. But when the safe deposit box is titled in the trust, you avoid that drill fee, which saves time and saves money. So if you have a safe deposit box, you're going to want to take your trust to the bank and have the bank retitle that box so it's in the name of your trust. So now the trustee has paid the bills of the decedent. Now the 90 days has expired. Now the question for the trustee is what happens next? And what happens next is now you have to send out a document to the beneficiaries called an accounting. And the purpose of an accounting is California law requires that the trustee prepare a financial memorandum for the benefit of the beneficiaries, showing what assets were in the decedent's name on the day that they died, what assets have come into the estate since the person's death, and what assets have been paid out of the estate. So really the purpose of the accounting is to make the trustee be transparent to the beneficiaries in showing the beneficiaries the financial status of the estate. And in the accounting, the trustee at the bottom is going to show what they anticipate each beneficiary's share to be. But having said that, let me just real quickly note that if I have a trust and if my trust gives a $10,000 gift to UCSD, because UCSD is getting a specific dollar amount for my estate, they are not entitled to that accounting because they are getting a specific gift. But if my trust says that UCSD gets a 10% distribution of my estate, then UCSD is entitled to the accounting because the whole purpose of the accounting is to show UCSD when they get that distribution for 10%, this is how the trustee got the number for the distribution. So preparing the accounting is a document that the trustee actually wants to start working on at the beginning of the trust administration. It's almost like a check ledger, if you will, where you start with certain assets come in, certain assets go out. Most trusts do contain language that allow the trustee to pay compensation to themselves to be a trustee. Under California law, 1% is presumed reasonable compensation, and that's 1% of the net value of assets. Or it could be gross, but I always encourage clients to take the net value, not the gross value. And if you do decide to take trustee compensation as the trustee, you do have to include that in the accounting because that does become an expense of the estate. It's important to know that when a trustee does accept compensation, it is taxed as income tax because you are getting paid for a service. So anytime a trustee takes reasonable compensation for their time and trouble in administering an estate, it is monies that are taxable to that trustee. Oftentimes a trust will also have language that if there are two people named as co-trustees and they're sharing the job as trustee, they will split that 1% and each of them will get half of that 1%. If you are a trustee and if you don't want to take that trustee compensation, you do have the option of waiving that compensation or taking a smaller amount. So most trusts do authorize trustee compensation because generally it is a good idea to pay the person who is taking on this legal responsibility for their time and trouble of administering their estate. Now, sometimes people, instead of paying the lump sum, they'll choose to pay an hourly compensation, and you can decide what that looks like, whether it's $50 an hour, $150 an hour. I'm not as big of a fan of hourly trustee compensation because now you're imposing an additional duty on the trustee to keep track of their time. And I find that sometimes trustees grumble about that because it's more work on top of the work that they're already doing. But you can do that. And then sometimes people will say that they don't want to pay trustee compensation, which is also an option. So once the trustee sends out the accounting that shows the status of the trust, then the beneficiaries have 180 days to contest the accounting. So in California, generally the quickest a trustee can actually make distributions from a trust after a person dies is 9 months. Because first you have to send out the notice to the beneficiaries, which opens and closes the first statute of limitations for the beneficiaries to contest, which is a 90-day statute period. And then you send out the accounting, which opens up the final contest period, which is 6 months. So what we typically do for our clients, if they want us to, is we can prepare a document called a waiver. And the purpose of a waiver is if, let's say, there's 3 beneficiaries inheriting from an estate, and if all 3 beneficiaries sign off on a waiver in writing where they agree that they've read the trust, that they have no objections to the trust, that they have no objections to any of the decisions that the trustee has made, and they have no objections to the information contained in the accounting, and they waive their right to contest the estate, they waive their right to contest the accounting, and they waive their right to sue the trustee. If all the beneficiaries of a trust sign off on that waiver, waiving those rights, then a trustee can make distributions to the beneficiaries earlier than the 9-month period. So I find that when we help administer trusts, usually the trustee is able to make distributions within a 3 to 4 month period, sometimes 6 months. Sometimes trustees want to wait the full statutory period because they're concerned about a beneficiary trying to litigate or file a contest, so they have a peace of mind just waiting the full statutory period, which they're legally able to do. And then what happens in California is once all the assets come out of the trust, once the trust is deplete of assets, the trust terminates by operation of law. And that's when the trustee's job is over. So in a nutshell, I know I just went through a lot of information, but that's really the life of a trustee. If I pick Suzanne to be my successor trustee and I'm hit by a drunk driver, one role she has is to manage my financial affairs when I lack capacity and can't manage them for myself. And what that basically looks like is she would have access to my funds. She would step into my shoes financially. She would pay my bills and my taxes. And then when I pass away, the second job of a trustee is trust administration. And that is the job of of sending out the notice to beneficiaries, making sure that there's not a probate that's required, then preparing the accounting, sending the accounting, and if agreeable, the waiver, and then making all of the distributions to the beneficiaries. So then probably the most commonly asked questions people ask me is, who do I pick to be a trustee? And that is a really good question, because when you pick a trustee, that person really is your lifeline. So you're picking a person who's trustworthy, who's good with money, somebody that would be impartial to your beneficiaries, treat them fairly, have good communication, and you want somebody who's proactive. I had a client once who was a trustee, and she was so grief struck when her parent died that she just didn't have the heart to sell the house. So she came in and I helped her with the trust administration and the initial phases. And then a couple of years later, she called and she says, I still haven't sold the house. And I said, what do you mean you haven't sold the house? I said, your parent died a couple of years ago. And she says, I know, I can't. It's too hard. It's too emotional. That was my family home. And I said, but you've got these 4 brothers and sisters. I said, I'm so surprised, with all due respect, that they haven't given you more grief about not listing that house for sale. I said, have you been renting it during the last couple of years? And she said, no, it's just sitting vacant. So it's important to understand also that when you pick a trustee, when a person agrees to be a trustee, they are agreeing to do a job. So I know this sounds super indelicate, but when you are a loved one of a decedent and you agree to be their trustee, you legally don't have the ability to tell the courts, oh, Your Honor, I'm so sorry. I sat on this asset for a couple of years because I was sad and I was grieving. With all due respect, and not to sound indelicate, the courts don't care, because when you agree to do a job, you're agreeing to administer an estate. And in California, you are given what's called a reasonable period of time to do that administration, which, depending on the complexity and assets of the trust, most trusts can be administered within that 9-month period without any problems, if not sooner. So if you have a trust that's pretty straightforward, and if assets are sitting in the trust, and if they're not being made productive by being rented, or if they're not being sold, if any of her siblings would have taken her into court and challenged her, the judge probably would have terminated her as the trustee and let the next person in line take over as the trustee. So I will say, I have had a friend that passed away recently, and I was nominated to be a trustee on her trust, and I declined because I knew, to be honest, that it would just be too difficult for me emotionally to be the trustee administering her trust. So you do have the ability to decline these nominations when presented with the option of accepting or declining. And sometimes, like in my situation, I knew it would just be too difficult, having lost a dear friend from cancer, to be the person going to the bank and to be the person being the liaison of paying the debts and communicating to the beneficiaries. It honestly was something that I was still so sad and grief struck from her death. I didn't feel I would be the best trustee. And to be honest, I didn't want to be the trustee. I just wanted to be able to grieve and not have that job. So when you pick a trustee, oftentimes people will pick their loved ones. It's not uncommon for people to pick their adult children. People will ask me all the time, is that a conflict of interest? And the answer is no, it's not an inherent conflict of interest. If you have an adult child that you trust, that's good with money, okay, Suzanne, that's a good question. That you think would be fair to the other beneficiaries. Sometimes I think having your adult children are your best choices, because oftentimes they are the people at your bedside in the hospital, and they are the people that are more familiar with your assets. Suzanne just posted a really good question, and that was, what happens if all the people decline? And that answer comes down to, how is the trust written? So in my trust, my default says, let's say I have 3 trustees listed. If all 3 trustees that I nominate all decline to act and are unable to act, then my trust has language that says any of the 3 of them can pick a successor trustee if any of the 3 of them are able and willing. But now let's say that none of the 3 people are able and willing to be a trustee, and I still don't have a trustee in place to administer my trust. Then the trust says that by a majority vote of the adult beneficiaries, they can pick a trustee. But let's say that the beneficiaries of the trust can't agree and can't reach a majority vote, then my trust says in that situation, which, to be honest, it's very unlikely. I've actually never in 20 years of practicing law been in that situation. But if you were to be in that situation, then my trust says that a court by default will pick a trustee. And oftentimes, if the court is picking a trustee, the courts are always going to pick a private fiduciary or a corporate trustee. So in a trust, in a durable power of attorney, you can pick loved ones, you can pick family and friends. A trustee doesn't have to be a blood relative. A trustee can be your best friend and next door neighbor. You can put contingencies on a trustee nomination. So sometimes I'll have people that want to pick a son-in-law or daughter-in-law. but we can put language in the trust that says that individual is only eligible to be a trustee if they're legally married to or widowed by the son or daughter at the time of acceptance and while serving to continue to be eligible to be a trustee. So that if a person, let's say that my daughter is married to somebody and I have him as my successor trustee, but I'm in the hospital and I'm incapacitated, and sadly my daughter and her husband are going through a divorce, I can already anticipate that situation in those documents so that he's no longer eligible to be my trustee, because if I'm alive and I lack capacity, I can't update those documents. So these documents can have contingencies in place. I've had some people say that they want their mom, for example, to be a trustee, but only if mom is under the age of 85. I don't tend to like those kinds of contingencies, because I think there's a better way of approaching that, because the trust already has language, as does the durable power of attorney, that says that if a person nominated to be a trustee is legally incapacitated at the time of acceptance, they're no longer eligible to be a trustee. So if you did pick an older loved one or family member to be a trustee, and if at the time that they needed to make a decision as to whether or not they're able and willing to be your trustee, if they do lack capacity, they're automatically ineligible to act under California law. So you don't have to put age contingencies in place unless you want to. So you can have a family member or a friend as a trustee. Let's talk about corporate trustees and private fiduciaries. So the difference between a corporate trustee and a private fiduciary is a corporate trustee is a bank. Most banks now have legal departments with their own trust departments. So I guarantee for everybody who's attending the Zoom, if you bank at Bank of America or the credit union, the majority of banks all have trust departments and are willing to be your trustee should you pass away. The issue with corporate trustees, in my opinion, is most corporate trustees are willing to be your trustee when you die, but they're not willing to be your trustee if you're alive but lack capacity. So I have a lot of clients that bank at Wells Fargo, or at least I used to have a lot of clients that did, and that Wells Fargo is happy to be a trustee when you pass, but they don't want to be a trustee while you're alive and lack capacity, because they don't want to be in charge of paying your bills, but they are willing to be in charge of managing your monies after you die and making the distributions to the beneficiary. So if you want a corporate trustee, then you oftentimes have to also nominate an individual to be your incapacity trustee, because most corporate trustees won't do both. They'll only be your trustee when you die. They aren't willing to be your durable power of attorney and trustee while you're alive but lack capacity, and that's important. So one benefit of a private fiduciary is a professional trustee. So this is an individual who's licensed and bonded to be a trustee. The nice thing about a private fiduciary is they are generally willing to be your trustee while you're alive and lack capacity and after you pass away. So I do personally, if I had a choice between a private fiduciary versus a corporate trustee, it's probably going to sound surprising, but my preference would be to pick a private fiduciary versus a corporate trustee. And the main reason I say that is, one, I like the consistency of a person being a trustee while you're alive but incapacitated and staying on and continuing to be your trustee when you die. I like that continuity. The other thing I like about a private fiduciary is if your trust has provisions within it that gives your trustee the discretion as to making distributions for a beneficiary. Most private fiduciaries are willing to roll up their sleeves and get their hands dirty and exercise that discretion and exercise that tough love. So I have a clause in my trust that's a drug testing clause that gives the trustee permission to ask a beneficiary to take a drug test if the trustee reasonably believes that a beneficiary is having issues with illegal drugs. Most corporate trustees won't trigger that clause because they're afraid of being sued. Most corporate trustees, when it comes to exercising discretion, don't want to exercise discretion because it's a gray area of the law, and usually it's in the gray areas of the law that a beneficiary can lawyer up and take a trustee to court. Whereas if it's black and white, that a beneficiary gets X% at age 25 and X% at age 30 and X% at age 35, no discretion. But if there's a clause that gives the trustee permission to drug test a beneficiary, Most corporate trustees will not trigger those provisions because they don't want to take the chances of being sued. Whereas most private fiduciaries realize that part of what their value to being named in these documents is they can tough love your beneficiaries. And usually when you name a private fiduciary, you will have interviewed them, you will have talked to them, you will have explained your family situation, explain your concerns so that the private fiduciary is knowledgeable about what your concerns are and what you want them to be looking for. So they're more apt to be willing to make those discretionary provisions. So if you had a choice between a corporate trustee and a private fiduciary, I would just keep these things in mind. The other downside, in my opinion, about a corporate trustee is you don't know who that trustee is going to be, because the personnel in a corporate trust department changes. So the person who's in charge of trust administration today may not be the same person in charge of trust administration in 25 or 30 years. But with a private fiduciary, you can always update who those individuals are. So if I have a private fiduciary in my trust who's, let's say, 75 years old, and I know in probably 10 to 15 years, I might want somebody who's maybe in their 60s as a trustee, I can always update my trustees and change the order of who they are. So you have the ability to update these documents, to change who your trustees are. You also have the ability, when it comes to professional trustees, to interview them, to ask them the questions about their approaches, their processes. You also want to ask them about how they charge. So most corporate trustees are going to charge a percentage. Sorry, my throat gets dry. Most corporate trustees will charge a percentage of the estate and fees. Most private fiduciaries, sorry, can charge a percentage or charge hourly. My voice is going for some reason.
Take a minute, kiddo, drink some water. All right.
It's the changing of the seasons that gets me every time. So when you nominate a corporate trustee or a private fiduciary, you do want to ask them about how they charge fees. Are they going to charge a percentage, or are they going to charge an hourly fee? Because legally they can do either one. And you're going to want to know that in advance. You're also going to want to ask them what their approach is as far as the trust administration. So you're going to find most corporate trustees and private fiduciaries are going to want to review your documents while you're alive. And that's a really good idea, because you want to make sure that they understand the documents. You want to understand that, you want to make sure that they're comfortable with the documents. Every once in a while, I'll have somebody who will talk to a private fiduciary or a corporate trustee, and they might want me to change the language just a little bit about compensation or any other provision that they want to be worded a specific way. So anytime you do pick a corporate trustee or a private fiduciary, you do want them to review these documents. And if they don't ask to review the documents, that might give you some pause, because you really want them to have reviewed them, to be comfortable with them, and to have had an opportunity to discuss those documents with you. When you name a private fiduciary or a corporate trustee, I still want you to have a first, second, and third choice, because there's always a possibility that that corporate trustee may no longer be around, because banks do merge. So if you had Washington Mutual as your trustee, Washington Mutual has now been bought and sold. So you always want to make sure that you're reviewing your trustees, that your trustees are still who you want in the order you want. People do tend to change their trustees in these documents more often than they change any other thing in an estate plan. So for that reason, I discourage clients from sharing their documents with all the trustees. If you've got family members or close friends as your trustees, I do think it's important to tell them that you have an estate plan, tell them where you're keeping the estate plan, make sure that they have access to the estate plan. But because people will change who their successor trustees are, whether that's because of a broken relationship, or maybe somebody marries somebody that you're not so fond of and you don't want them influencing a person's decisions, I don't think it's necessary to give copies of the financial documents to your loved ones while you're alive and have capacity and are healthy. As your health starts to change, I do think it's important for people to consider maybe bringing on a trustee as a co-trustee while they're alive and have capacity. When it comes to elder law and elder abuse, unfortunately, that is the #1 crime in the United States. One way of protecting yourself from elder abuse would be to step down as your trustee when you get to a stage in life when your capacity is starting to slow or diminish, or when your physical ability to get out and about is starting to decline. When you bring on a co-trustee and teach them about your monies and how you do your monies, once you have somebody in place who's competent that you trust, you can then step down as your trustee, knowing that that person is at the helm of the ship and you've taught them about all of your debts and assets. And that is such a nice peace of mind. When people are hesitant, which I understand, to bring people on in these roles, it is a more difficult adjustment for people that haven't had the ability of you teaching them about your assets and your management of your assets while you had the ability and capacity to do so. So that is a piece of advice that I do encourage people to consider, is that at some point in your life, you don't have to give these powers away. You don't have to step down as a trustee, but if you brought on a co-trustee and taught them about all of your assets and the management of your assets, when you lose capacity or if your physical ability starts to decline, it's just a nice peace of mind to know that the person you trust already knows about all of your assets and how to manage and deal with them. So I think that's pretty much everything I wanted to cover today about trustees. I hope that was helpful. There's a lot of information. Being a trustee is a very important job. When it comes to picking your trustee, it is a decision you don't want to take too lightly. When it comes to making a decision, if you're willing to be a person's trustee, that also is a very important decision to consider. And if you are a trustee, most estate planning documents have the flexibility of resignation built into them. And if a person nominated to be a trustee no longer has capacity, they are no longer eligible to continue to act. So in a nutshell, that is estate planning trustee 101. And it's the trust and the durable power of attorney that give those powers. So I hope that was helpful. Suzanne, I don't know if we have a whole lot of time for questions, but I'm happy to answer questions if there's
If we could do a few questions, I'd really appreciate that. I know from personal experience this last year, I had a friend who had someone, a family member who died, and they had been named trustee. And after that experience, it was such a long and detailed process. She said, never again. I'm younger. I've had friends that have asked me since then, would you be my trustee? And she's declined flat out and said, thanks, but no thanks. I care for you dearly, but go somewhere else. I'm not willing to do that again. So do you recommend that people like really talk to the person they want to nominate and explain to them what is all involved before, getting them to agree to be trustee?
So I do think it's important to have a conversation with your loved ones. And I think it's also important to preface that conversation with the fact that you're not asking them to do the job today. I think sometimes when you have this conversation with people, instinctively a person's gut reaction is, I'm super busy, I can't do this right now. But the goal is just to friendly remind them that you are just putting these documents in place. You're hoping that this won't happen for a very long time. They do have the ability to accept or to decline the nomination, and they do have the ability to resign at any time. I think part of the reason why it is so difficult to be a trustee for somebody sometimes is because you don't have all the tools to be a trustee. And part of the tools is making sure that in your estate plan, you have all that asset information. I think that if I were your successor trustee, Suzanne, as an example, if you had in your estate plan all that bill paying information, so I knew what bills you had, when you paid them, how you paid them, logins and passwords. There's also a place in our estate plan where we ask people to put the names and phone numbers of their CPA, their estate planning attorney, the contact numbers of all the beneficiaries, so that way, basically in a nutshell, the goal is you want that estate planning binder to have in not only estate planning documents, but the financial information and the contact information so that the trustee's not having to go and reinvent the wheel and find all that on their own. So I think the more detailed we can be when we put an estate plan in place by having all that information in the binder, contact information, financial information, I know from experience that makes the transition a lot easier. I've had clients bring their trustees to meet me and have me go through their estate plan with the trustee and explain the process. I honestly don't think that that's very effective because I feel like the minute people walk out of my office, they forget everything we just talked about, which is fine. It makes sense. So I don't think it's worth spending a lot of time going through documents while a person's living with the trustee, unless it's a corporate trustee or a private fiduciary. But if it's an individual, I think the most important thing is to let them know that you want them to hire an attorney, because really the whole purpose of the attorney is for them to hold their hand and walk them through the process. And I think that makes the process a lot easier. I think sometimes when people try to be a trustee and they don't have the benefit of legal advice to know what the process entails or what they're supposed to do, I think Google can only do so much. And sometimes you can kind of run into circles and that can be frustrating. And on the other side, beneficiaries can sometimes make the job of a trustee really difficult, because sometimes you've got beneficiaries that are super impatient and super pushy, and that can be difficult. I see Simone is asking me if I have a recommendation for private fiduciaries. I do have a list. If you want to email me, my email is on the chat. I can send you the list of the private fiduciaries that we've worked with and recommend. There's a lot of really good fiduciaries here in San Diego. So the good news is there's a really good sea of fish that you can fish from. There's some really good people here in San Diego.
I just wanted to add to that, this person who had the difficult time being trustee, it was the issue of the beneficiaries. She actually got sued twice by beneficiaries who were unhappy with, the initial documentation of what the distribution was going to be like. And so it can be really difficult if you have problematic family relationships with beneficiaries. And so, I really learned a lot from my friend from that experience. They can be really, really challenging.
It can be. It can absolutely be challenging. And then the other downside is, I've seen it where people they have the discretion to give monies to a beneficiary over their lifetime, but they also have the ability to make an outright distribution. And the beneficiary tells the trustee, trust me, I'm good. Just give me the money. I'm fine. I'm good. And so the trustee agrees and gives them the money. And then the beneficiary sues the trustee on the pretense of, you shouldn't have given me the money. I just spent it all and now I have no money. I think part of putting a really good estate plan in place is having those difficult conversations with your estate planning attorney too. I think it's really important to come to those meetings with your attorney, explaining to them what potential problems there are in your family and amongst your friends, so that the attorney can help plan around those things. Because certain assets like retirement assets pay directly to a beneficiary. So if you've got a problematic beneficiary, maybe don't give them assets from the trust so the trustee doesn't even have to deal with them, but give them assets like retirement assets that pay to them directly, so they get their monies directly from the financial institution and the trustee's not even involved.
Right. Right. And I just want to mention, you were so helpful when I was doing my own estate plan. I have two daughters, neither of which want to be trustee, but we wrote it into the plan per your recommendation that the two of them get together and nominate a fiduciary and then exercise some sort of review control over what the fiduciary is doing. So I thought that was an excellent way to go for myself.
Thank you.
All right, are there any questions, other questions from members?